All right. Hello and welcome to our Summer Associate Series webinar, the AI Playbook for Junior Lawyers, Firm Policies, Best Practices, and Real World Lessons. I'm Vicki Adams, Director of the Institute for Energy Law and Vice President at our parent organization, the Center for American and International Law. Today's program is hosted by the Program Subcommittee of IEL's Young Energy Professionals Practice Committee. This is the first webinar in a two-part series of webinars designed for summer associates. Our moderator today is Laura McGonagill. Laura is a senior associate with Baker Botts in Houston. Her practice focuses on energy, including oil and gas, power, renewables, and also water. She's a member of IEL's 6th leadership class and is on IEL's Young Energy Professionals Council. She is also the chair of the YEP programs subcommittee. And now I'm going to pass it to the panelists, Adam and Reeny, to kick it off. Thank you.
Yeah, hey everyone. I'm Adam Whitehouse. I'm a partner in Houston at Gibson, Dunn. I am on the transactional side, and my practice focuses on oil and gas and really anything energy related. Recently, like a lot of attorneys, I feel like it's been very data center focused, but on the power and energy side. And I am the current chair of YEP for IL, and I was in the fifth leadership class. Is that right, Vicky, maybe? I was in one of the leadership classes as well.
Hi everyone, I'm Reeny Phillip. I'm a litigation associate at Mayer Brown, where I am in their where I represent companies in high stakes commercial disputes, intellectual property disputes, and energy disputes across state and federal court. I'm based in Houston, but I'm licensed in multiple states. My practice focuses primarily on unfair competition, trade secret misappropriation, and contract claims. I was a part of IEL's most recent class. I think that's the 8th leadership class. And so I am fairly new to IEL, but I've really enjoyed being a part of the organization.
Thank you both very much. As you can see, everyone, we have one litigator, one transactional attorney, and so I will try to kind of tailor my questions to their practices and to get us both perspectives of AI use from both the litigation and transactional side. And so with that in mind, kind of first question, how do you both use AI in your day-to-day practice? Adam, I guess we'll start.
Yeah, I'm happy to start. Yeah, I use it a lot. So I essentially think of it as using AI almost like working with a junior associate or mid-level. And I mean that in a few regards. So I use it to review documents. I use it to draft. I use it to prepare issues list when I receive turns of documents. I use it to prepare presentations. I use it when I speak at conferences to prepare, questions or then responses for that. And when I say I kind of use it, I work with it like I would an associate because I'll plug something in, but then I review everything like I would if I got work from another attorney. I don't take any of it as gospel and true. I double check everything and make sure that things were correctly summarized or identified.
Yeah, I can speak to it from a litigation standpoint. So I feel like you can use AI quite a bit in litigation, but I think with recent case law that has repeatedly made headlines, it's important specifically in litigation to verify everything. But I think one of the biggest, but also one of the most riskiest uses of AI is using it for legal research. I think it's really great to kind of look at like nuanced topics. Westlaw and Lexis AI platforms are able to quickly kind of give you a summary of cases, and you're able to then verify what each of the cases say and the principles that the cases stand for. I also use AI for kind of like my document review and summary analysis. So, for example, if you have like 1,000 documents that you need to get through and you have to get back to the client with advice fairly quickly, you can at least prompt it with hey, I'm looking for these relevant documents, and it can help pull the relevant documents that you need to review in order to give the client that advice, because a lot of times you're up against a tight deadline. And then I also use it in terms of like discovery and initial drafting. Like you can input certain documents and have it kind of spit out an outline for you, and then I think it's a good starting point for a lot of things.
And
You
not
both, sorry, go ahead.
Oh, I would say, and maybe not to maybe jump ahead to a question, but then for the use of summers or junior associates, I think it a similar uses. You use it for the same things, and then I think the hope. I know people talk about being scared of what AI will do to people's learning and training, but I think the hope is that it essentially is like you then got work from a competent associate that you're reviewing, because as you get more senior in our jobs, well, I think one of the biggest changes is how when you're reviewing someone's work instead of doing everything initially yourself, it really opens you up to think more big picture and not be just like down in the weeds, but I think do a better job of thinking big picture and making sure you hit all the points. And so when summers or junior associates use it, I think it should be used in that same way too. You're not just getting something, copy and pasting it. You shouldn't be doing that. You should get it, review it as if like someone had done the work for you. You're reviewing it to make sure it all checks out, and you want to make sure you actually understand each thing that's in whatever you're working on, whether it's transactional or litigation, just like you would if non-AI, if an associate or someone else gave you their work product.
So that's exactly kind of what I wanted to ask next, is that both of you kind of described using AI as an initial first step, which traditionally has been kind of the role of the summer associate or the first year associate. And so how, as a summer or a first year, can you ensure when you're using AI to kind of develop those skills in terms of um, kind of getting those building blocks of how a case works if you're not the one actually taking the first cut? And you kind of hinted on it, Adam, when you said, review it with a big picture view in mind. But can you expand a little bit more about that and things that a summer associate or a first year associate may want to think about when they kind of get the first cut from AI?
So not to be judgmental, but when stuff does get passed through with errors, I kind of view it as it's not an issue that you used AI. It's you have flaws in the way you do your work because you should not be passing on anything that you have not reviewed and checked and scrubbed. So, at points in your career, not as a summer associate, but at points you're going to have people under you and junior to you. And so you just frankly have bad work habits and bad process if you were passing stuff on without reviewing it. I think about it from this perspective, from the top, from the partner. I don't get to send work, and then if there are issues or we miss something in the agreement, be like, oh, I'm sorry, my first year did it. Like, you're responsible for everything you send and pass on. So you should be reviewing everything as if you're the one doing it, not copy pasting. And like I said, that's a broader, I think people are having issues AI with that. That's a broader indictment of the way they're doing their work.
Yeah,
And so,
piggybacking.
go
Sorry.
ahead.
I
No,
was just gonna say, piggybacking off of what Adam said, though, I think every summer associate or junior associate should approach work product that they get from AI as if they were the partner, right? So let's say you're the partner, you're reviewing the associate's work. In this context, the AI is your associate, because like a partner's not going to put their name on something that they haven't vetted. And just like that, no summer associate, no junior associate should be willing to put their name on something or be willing to risk putting the partner's name on something that they haven't vetted.
so how do you both, and this is going to differ, right, for litigation versus transactional, but how do you approach a document then? And maybe this is just, general transactional litigation advice per Adam's point about you should be reviewing everything. to become a better litigator or a better drafter on the transactional side, as opposed to just being faster? I guess kind of what questions help you to look at a document? And I guess now we're speaking a little bit more broadly, not just an AI document, but any document of fitting it in to the big picture. What questions do you ask to kind of tailor things, big picture, when you're looking at AI?
Do you mean like when we're reviewing or asking, like the prompts almost, like asking
When
AI?
you're reviewing, so if I'm, a first year associate and I get an assignment to draft a motion for summary judgment, let's say, again, I'm coming from a litigation perspective, and I put it into AI and I get something out, and I think, great, this didn't take me long. I'll make some edits, fix some typos, and like, look, that only took me an hour. I'm going to go watch the Astros now. Kind of, what are some safeguards? And maybe, this is too high level. It's obviously going to be case by case, but questions or things you can ask yourself, because the three of us on this call know very well that's not sufficient. There's so much, to tweak. And I'll give an example. My question's not clear. One thing I think AI struggles with, at least in the litigation department, is or sphere, is the order or the structure of a document. I find that a lot of times AI might kind of put a lot of points in that I think are good points and things we may want to raise, but the order in which it does so, I think a lot of times it front loads arguments that I think are much less important than arguments it kind of puts in a one-liner at the end. And so that would be, from my own experience, that would be one piece of advice I have for a junior associate getting work product back from AI is pay attention to the structure. That's one way you can add values. You get this work product back, think to yourself, is this really what I want to lead with? Do I really want to lead with a recitation of the rule, or do I want to lead with kind of the practical implications of why the judge should make this decision? And the answer can be different from either case, but just something to think about. Are there any kind of things like that you've noticed in your use of AI in your practices that younger associates can keep an eye out for as they edit that product, that might help them learn the strategy behind just the document?
Yeah, no, I mean, I think kind of building off of what you said, Laura, like, for example, right, I was drafting a brief and I had a paragraph that was extremely wordy, and I was cutting it down, cutting it down, cutting it down. And I was like, you know what, let me pop this into Harvey and see what it suggests I should cut out. And so I put the paragraph into Harvey and it gave me suggested edits. But the thing was, it took out facts that I knew would be very relevant later in the case. And so I think it's really useful in terms of helping with certain editing like that. But at the end of the day, you have to make the legal judgment because it's not thinking legal strategy. It's not there for like those conversations that you have with partners or senior associates of like, this is what's important to the case, this is what's important to the client. Same kind of deal with respect to like when I have it kind of summarize some documents, that way I can put it into, let's say, like a memo to the client, and I want to include some facts, and I first have it do a first run through of the documents. I have it cite the documents it looked at, and then I look at those documents, and sometimes the like facts that it says that it took from those documents are kind of taken out of context. And so I think what's important is, as junior associates and as summer associates use AI in their practice, they have to think about like the context and the broader picture.
Yeah, and I think adding on to that and maybe even partially what you were saying, I think, and tying back to even the prior question too, I think you just don't treat it differently than any other work you're doing. So at a firm, you should think of whoever's above you and all the people above you at the firm as your client. So if you're summer, that's a first year even at the firm, all the way up to partners. Like they're your client. That's who you are trying to make happy. And you should think of all the work you're doing. You need to be able to defend everything you did, wrote, revised, summarized. So you likely will not be leading client calls as a summer or maybe first or second year, but every revision, everything you've summarized, every proposal, obviously I'm thinking more the transactional side, you need to be able to defend that if the client or the other side were to argue against your point. And so I had an example yesterday where I was putting something in a document. And I was like, oh, I kind of get it. And I almost just went with it. And I was like, no, you need to be able to defend it. You need to know what this means. So one way there to use AI is and you can drop it back in AI in Cloud and say, hey, please explain what this means. I mean, you can ask it. So everything you send, you should be able to defend. And that's how I think too, you can continue to learn even while you're using AI. Again, because you're not just copying and pasting, you're making sure you understand everything that's in there. And some of your other kind of related comments and questions, Laura. So I think too, it's great to, if you don't like the order, it's very easy to drop it back in and say, hey, this is how I want it ordered. And it does that all pretty seamlessly and quickly. Like on the transactional side, when I have a due issues list, sometimes I want it chronologically in the way it appears in the document. Sometimes I want it by the most important issues. And if it doesn't give you the order you want, you just, enter a new prompt saying, hey, please reorder these by the order they appear in the document, something like that.
Are there any circumstances in which you two never start with AI, or just kind of as a general rule, here are areas where you would not recommend to use AI? Or, do you find the trend to be use AI as step one?
I find myself not using as much when we're a few iterations in. And maybe that's just me, but I'm a pretty heavy user and adopter. But so the first time I get a document or drafting a document if I need help with something, or the first time doing an issues list or summarizing documents. But if it's like on the transactional side, if it's like the fifth turn of a document, so we're down to like 10, 20 revisions, and I know all the history. I know what I originally drafted. I know what they came back with. I know what I then went back with, and what I went, I know that whole history. It just then is when I personally don't see the huge value by dropping it in AI, unless though, then I want help drafting. Then I might drop it in and say, hey, I'm thinking about framing it like this. Can you please draft some language? But for me personally, it's when there's a lot of history to something. I feel like, then it's sometimes more efficient just to do it yourself.
Yeah, similar to Adam, like I might have AI give me an outline or do like an initial this is what I think. Like for example, like you can get a motion and you can drop it in there and say point out like the key arguments and like kind of outline based on those key arguments. But once I get that, I don't use AI to draft anything because I think you need to exercise independent judgment and you know the case, you know the facts. Like AI doesn't know everything that from being in the room, being on client calls, from all of that sort of stuff. And so I go through and I do all the drafting myself, and then I might drop it in at the very end to give me like potential revisions or edits. But I think it's important to not have AI do like the meat of the work simply because it's not going to know like all of the additional comments like the partner gave you in their office, or it's not going to tell you like some of like the values that the client has said is like really important to them as you argue their case. So that's why you can't rely on AI for like the actual substantive portion of your practice.
How do you both approach disclosing your use of AI to court, to clients, to your supervising attorney, and what should summer associates kind of best practices? How should they approach disclosure of their use of AI?
Yeah, so I think, well, at least for like our firm, we are required to first check if our clients allow us to use AI. And then after checking if our clients allow us to use AI, we're supposed to, communicate with our partners that we're using AI. And a big reason behind that is because at the end of the day, like if it's the partner's signature on the line of like a filing or a brief, they're the ones attesting to the accuracy of that document. And so you want them to know everything that went into that document. So I think it's important to have those conversations about like what you used AI for. And then there's also been like recent case law, like in,
Yeah, tell us the case that we had a discussion about this a little bit, but tell
yeah.
us a brief overview about the case that I know you're about to talk about.
Yeah. So like this was out of the Ninth Circuit. This was actually this year. Essentially two attorneys filed briefing that included non-existent cases and like severe misrepresentations of like the precedent, which didn't exist. And when the court addressed the fact that like, hey, like I think these are AI hallucinations, the attorneys weren't upfront about their use of AI. Instead, they tried to say that like it was it was inaccurate copy and pasting, that they like had there was some kind of typographical mistakes, and they didn't actually tell the court that they used AI until later on. And the court came down very hard on them because essentially the court said like the moment you sign and file something, that's when like you are testing to everything in that document and you have a duty of candor to the court. And so it changed the conversation from, hey, like, were you checking your research to make sure that it was what it was, to why weren't you being transparent with the court? And I like in some respect, I think they probably didn't want to expose themselves to the court because there have been so many kind of hallucination cases. Um, but that also turns to the point of like that's why it's important to verify everything, and that's why it's important to not put your name on something that you haven't verified.
Yeah, I think that makes sense. And I think kind of what you're hitting at the beginning of really, you just have to know your firm's policy, right? I mean, don't think anything we're saying is what you should go do. You need to know your firm's policy. I mean, each firm's going to have different policies. I think by now, all firms are on board with using AI, but still check, what it means to use as associate, what it means to use as a summer. Like I know my firm's been a very early adopter, and we have everything like on the transactional side, Harvey, Claude, Chat, Gemini, all enterprise. But this is the first summer we've allowed summers to use AI. So last year they were not. And I think that was in part, we thought for learning, in part just it was such a new tool we just didn't want to get in certain sticky situations. So they can use it now. And then like on the associate front, our policy is that every associate needs to ask the partner on the transaction before using it. Not like every use, but is it okay to use AI with this client while we're working on this? And so every partner should know. As far as disclosing clients, again, I mean, this is going to vary by firm, but it's not, I've not disclosed to clients, and it's not been a thing. But I also think it's kind of different on transactional versus litigation side. Like I said, on the transactional side, it's really just like I'm getting work product from a fifth year, and I don't tell a client, hey, this fifth year prepared the first draft and then I revised it. So I think it's a little different on transactional, but yeah, the key there, I think, is just know your firm's policies.
And I
And
think also knowing the court's policies that you work in, because like I think it depends on what circuit you're in, because different circuits have been coming down harder. I think it's kind of nationwide that judges are kind of skeptical of AI use, but there's certain circuits, certain courts that completely frown on AI use or completely prohibit it. So I think it's also being aware of whether you're even allowed to use it.
Oh, you mean a bunch of older people don't like AI?
Yeah, it's such a
shocker.
surprise.
Shocker. So building off of that, joke, with some truth behind it, the summer associates on this call and the first year associates, they are the younger people on this call. What can they do to help the team in terms of AI use and their knowledge of it? I mean, what types of things would you recommend they become familiar with, and how? And it sounds like Adam has some recent experience with some
Well,
AI training and things, but
I was laughing because I wouldn't be too optimistic about changing your firm's policies. I think though, yeah, so I mean, first I think your firm has to be an adopter, right? You're probably not
Sure.
but if your firm is, you may still have certain senior people who are not. And I've even run into that with more senior partners I've worked with. So a tact I've taken. I'm not suggesting anyone hide the ball, but I've sometimes done work and then not told them until after once they praise the work. And so they see, oh yeah, hey, I did a really good job.
Love that. Oh my gosh, love it. Love it. And so what do you use? We talked a little bit before this presentation about your technique about kind of double checking AI's work. Tell the rest of the group that story.
Yeah, sure. So we were talking about the uses, and like I mentioned earlier, my firm has been a very heavy and early adopter. We even have had partner-specific AI trainings. We had like an hour and a half on last week, and we hired this guy. His last name's Shapiro. I understand he's one of the top authorities and authors on the use of AI at law firms. And so um, we have them all. And what he pushed, I'm not getting paid by any of these companies, but it's Claude. He called Harvey just training wheels AI. So he uses Claude and Chat. And a few things he drove home was using them together. So I had already been doing, when I have a document I want an issues list, I had already been dropping into both. Because in my mind, I was like, well, two AI, don't catch this. It's not an issue type thing, while reviewing the documents too. But so I was using both. But what he prescribed was to, if you're like drafting a document, have one do it or draft a revision. And he liked Claude. So we'd have Claude do it. Then he would drop it in chat, tell chat, make it clear to chat that Claude drafted it. So knew there could be some errors. Tell chat, hey, Claude drafted this. Please review for all issues and prepare a list. Then he drops the list back into Claude and says, hey, Claude, will you please revise the document based on any of these issues you agree with? If you don't agree with any, tell me why. And then he does that 7 to 8 times. So keeps dropping the document back and forth between chat and Claude. And then the other big takeaway I had from that training was how much information he feeds the Claude or AI, and that I had been giving like a sentence of like, please flag all issues and propose responses. But no, he was giving like a whole paragraph and just speak to text, whole paragraph of I represent so and so, they're this kind of client. Please flag all issues and propose responses. We want to be middle of the road. We only have 3 weeks to get this negotiated. Here are some of the client's sensitivities, and gives it a lot more context.
Context matters. That would be a good tip and a good takeaway. Because I will say, just personally, I'm like, just kind of typing in quickly, like motion,
Yeah.
do it now, and I don't bother, I guess, to type in the names of the client, because I know that I can fix that, I can fill it in,
But
and so okay,
And to
context.
tie it to the earlier points, treat it like another attorney, right? You wouldn't just go to like a first year's office and say, hey, write this. You have to give them context, right? So same thing. When you probably go talk to a summer, first, second, third year, you're giving like a lot of context when you are asking for help with an assignment. And I think a lot of people aren't doing that with AI, but you need to treat it the same way.
It looks like we have a question in the chat, which is, can you speak on the news that Kirkland is making their own AI program?
I have seen that. Yeah, I've seen that and saw some articles on it. I will. I'll maybe leave it to people to go read some of the articles on it.
Yeah, neither of you guys are at Kirkland. I understand.
I worked there for 2.5 years. Um, but yeah, I just like maybe go read some articles. I don't know that it's gonna be that different than, you know, Anthropic is not giving them a secret sauce that they're not giving to everyone else, right? And I would guess a lot of it would be maybe similar to what I was saying about Harvey, where um, people who are full adopters and know what they're doing kind of just view that as training wheels. So
So One thing I want to be sure to talk about from a litigation perspective is AI and privilege, and AI and experts. So indulge us for a moment, Adam. Of course, privilege is privileged, whether in litigation or transactional, but kind of from the case law perspective and the recent decisions we've had, there's been some very specific kind of privilege issues that have come out that can be applied to the transactional context. So, Reeny, can you tell us a little bit about those recent cases and kind of the big takeaways?
Yeah, so I think one of the key ones is US versus Hepner. So that was out of the Southern District of New York last year. And it was a case of first impression because it addressed the question of whether when like a user communicates with a publicly available AI platform, whether those communications are protected by attorney-client privilege or work product. So just some like general background on the case. Hepner was indicted by a grand jury for alleged misconduct that he engaged in when he was serving as an executive at several companies. And he was charged with like securities and wire fraud, conspiracy, falsifying corporate records. And when authorities searched his house, they found 31 documents memorializing communications Hepner had with Claude. And so Hepner had used Claude when he found out he was being indicted to prepare reports outlining his defense strategy and what he could argue with respect to facts and law. And Hepner tried to assert privilege over these documents that the government seized, saying that he input information that he learned from counsel into Claude and that he had created the documents for the purpose of speaking to counsel and obtaining legal advice. And then he also said that he had shared like the contents of the documents with his attorney. But I think one of the key issues was that Hepner's counsel had not told him to use Claude. This was completely at like his own volition. He decided to use Claude. Ultimately, the court held that it was not work product because the doctrine of work product depends on the existence of like real potential that the actual documents would expose counsel's thoughts and mental processes related to pending or anticipated litigation. And here, like the AI documents couldn't be afforded work product protection because they were prepared by Hepner of his own volition, and the documents didn't reflect counsel's strategy going forward or at the time that Hepner had used Claude to create these documents. And then the court also said that these documents weren't attorney-client privileged because the documents weren't communications between Hepner and his attorney because Claude isn't an attorney. Like these were communications between a third-party platform and Hepner. And so like it's essentially the idea of having a discussion between two non-legal people about a legal issue doesn't make that communication privilege.
Or like Googling, right? That's what
Yeah,
popped in my head. Like just because you Google something, I mean, you've seen movies like someone asks like how to dispose of a body. You don't just say, oh, because I Googled that. It's like privileged.
exactly. Like that, and that was what the court said. The court was like, it's not between you and your attorney. You used a third-party platform.
Yeah.
It doesn't matter that it was AI or whether it was Google or whatever it was. It's not privileged. And the court, like specifically in its holding, even said like, privileges apply to human relationships, like attorney-client privilege, like a therapist and their patient, a doctor and their patient. It doesn't apply to a third-party platform and a human.
I wonder if one day we'll get there though,
It's
right?
a
Because lots
possibility.
of people are using it. I mean, I get so much stuff now from clients or like other sides opposing people who don't have counsel, and you can tell it was just spit out by AI, like with no oversight. So I wonder if we get to a world at one point where, yes, people are solely like retaining AI's counsel and yeah.
It's possible because so even in that holding, like the government, just to, challenge like the argument that it was attorney-client privilege, typed into Claude whether it could give the government legal advice. And Claude said, I am not a lawyer and I cannot provide formal legal advice or recommendations, and you should consult a qualified attorney.
Yeah.
And so
So, as I understand the holding, though, the court did kind of leave a caveat that had counsel directed Hepner to use
Oh,
AI, that AI could then potentially, and again, this was kind of dicta, but could have been qualified as an agent of an attorney. So in the same way, right, like if I'm communicating somehow with, maybe my legal assistant or someone that's not an
yeah.
attorney, but clearly kind of functioning on my behalf, then those communications are privileged. But as I understand it, the court did leave
yeah.
open, in the future, that ability that it might be
Yeah.
privileged.
No, that was one thing that like was interesting. And the court said like it could have been argued that
Yeah,
had the attorney told Hefner to use Claude,
right.
then Claude could be like akin to a highly trained, the court used highly trained professional who acted as a lawyer's agent within the protection of privilege. But here, Hefner had used it before counsel even knew he was using it. So the court said like, hey, Claude is not an attorney. The communications aren't confidential. Like a third party platform, like in the like user agreement, it says that the operating company can use that information to then train the technology as well as disclose it to governmental regulatory authorities. So yeah, it was a very interesting case because I think it raised questions of, okay, we need to tell our clients like, hey, don't go put what I told you into
Yeah.
Claude or Gemini. Don't go like as soon as you get sued, don't just start like AI legal advice seeking a bunch of questions without getting an attorney because like all of those things are discoverable.
That's good news that they still need us.
Yeah.
Yeah. And
Jobs.
from, for those on this call that are kind of junior litigation associates and thinking about like how they can add value, think of what this means in terms of discovery and discovery requests, both from kind of protecting your own client from this discovery, but also in propounding questions to the other side. One thing a lot of junior associates do in the litigation department, right, is maybe take a first cut at crafting discovery and think about whether AI prompts are relevant to your case and something that you want to ask for as part of your offensive discovery. Something to think about. So along those lines, and I promise after this question, Adam will return to maybe a more transactional view of the world as well. But Reeny, can you also discuss the case about experts coming out of Connecticut?
Yeah, so it was a recent, I think it was a few weeks ago. I think it might have been like 2 or 3 weeks ago. The case was Conservation Law Foundation versus Shell. And in that case, Shell and other defendants moved for an order compelling CLF to produce materials that an expert witness relied on in producing their expert witness report. Essentially, like in the expert witness report, the expert disclosed that they used AI to refine what kind of documents they needed to review in order to produce their expert report, and they tried to argue that they had a Rule 29 stipulation that said like they wouldn't disclose or wouldn't ask for notes, communications, that kind of stuff that the expert relied on. So CLF's argument was, hey, like even though my expert used AI to refine what documents they relied on, that constitutes part of like the notes and other communications that experts don't have to disclose. Ultimately, the court held no, like the expert had to go ahead, or they were entitled to ask the expert through request for production and interrogatories to produce all of their AI prompts that they used in creating their expert report. And I think that raises a lot of questions of kind of what litigators need to think about when structuring their expert retention agreements, when having conversations with their experts of like, hey, what are you using AI for? How much are you going to use AI? What documents are you going to upload into AI? So I thought it was like a really interesting opinion that still leaves kind of like the question open of how do we have experts use AI tools in like a privileged context?
I have questions. I would have thought they would have gone the other way. So sorry, if someone's using, if an expert's notes aren't discoverable, is that what I heard?
Yes, they had entered like a stipulation that the expert's notes weren't discoverable.
Oh, that was just that specific thing, or in general, is an expert's or their notes discoverable?
So it depends, but generally the like certain communications and notes are discoverable, and then certain communications and notes aren't.
Oh, okay, okay. So like
Adam,
even
we got to get you O'Connor's Texas rule book for you to use.
no, I was going to end this by telling everyone they should do transactional, not litigation.
Well, okay, here's a question from a litigation perspective, but like a transactional question. I have a case right now where we are arguing about it's a commercial dispute over a contract, and we're arguing about kind of what the terms of the contract means. And the parties in discovery went back, asked for drafts of the contract to kind of inform terms. And there's, a bunch of case law. It depends what jurisdiction you're in, whether that can be used, et cetera, in an unambiguous agreement versus an ambiguous agreement. But you always ask for it in discovery. One side's always going to want to use it, right? And so from a transactional perspective, generally, do y'all ever think about that your drafts might be used in litigation 10 years down the line, but also how AI discovery of like the prompts or the drafts put into AI and what AI came out with, maybe that'll be discoverable. Do clients have to put a hold on that, right? If you're arguing over, oh, we think the term means A, and they say, no, it definitely doesn't mean A because we struck a sentence that said the contract means A. We struck that from the agreement as part of the drafting. And AI told you that if you strike this agreement from the drafting, that might be, I mean, it just gets into all sorts of issues. Query whether they're
Yeah.
privileged.
Well, I was gonna say, yeah. So to tackle parts of that, so that towards the end, wouldn't the AI be privileged? Because I get why the drafts aren't, because the drafts went to the other side, right? So that's not privileged. But everything you did internally, unless you used AI and then copy and pasted that to the other side to say, like,
Yeah.
AI says you're incorrect because of this. Otherwise, if you just used AI, wouldn't that all be privileged? That was my understanding, because that would be just like using notes internally. I mean,
So
we
maybe,
are the attorney, so I thought,
right? Like, yes, if you are the attorney using it,
yeah.
probably.
So
But if you're the client using it, is it privileged?
mm,
It's kind of an
no, yeah, I thought that's what we
really,
talked about earlier. But so yeah, you were asking though us on transactional side, we think about it. No, I don't think about what I put in AI for that context because my understanding is privileged. Now, the nuance where it does matter is if you ever get into litigation with your client, right? Because then they're
right,
going to waive privilege. So
right,
then everything is on the table, right? You're like
right.
notes, email drafts that you never even sent to anyone. So, but no, I wouldn't, I don't go through each transaction imagining I'm going to be in a lawsuit with my client, one. And then, so no, I don't think of the, even though it happens. So I don't think of the AI in that capacity. In terms of drafts, no, not at all, because I'm just drafting what I think is best for my client and what needs to be done, right? There's never, it'd be too hard, difficult. I don't know that it would change anything to think of everything of like, well, here's what I want, but how do I set it up so that if we're ever in litigation, this looks like we meant this instead of that, you know? So no, from a drafting perspective, you're really just saying what's the best language? What do we want in here? Again, where that, what is kind of analogous that I think of is when you are worried about certain clients. so not the other side. That's when I may get more careful with how I word things. It's not uncommon to send an email, then bump the email to everyone else on your internal team and be like, we're sending this one to the file. So that type of thing, I may be more careful internally. But for as far as the other side, no, I wouldn't say I ever think about drafting in that context.
I also think sorry, I was just gonna say, I think it's important for us to clarify for the summers that when we're talking about what's discoverable and what's not from from a privilege standpoint, like if you're operating within your a firm approved like Harvey AI technology, usually that is privilege. But if you just go on Google and you use Gemini and you plop something into it, and like it's not something that's only within your organization, it's something that is the third party public platform like we talked about in the Hepner case, then it might be discoverable. So that's why you don't want to do that. You only want to use like firm approved like enterprise systems. So that way it's operating within the confines of like the protections of your firm and not just like open to like third party, the world, and teaching Gemini confidential information.
Yeah, just on that point, I know we hit on to learn your firm policies, but yes, everything we've been talking about is enterprise. It's all within your firm. Everything's within the ecosystem. So Claude, Chat, Gemini, Harvey, you should not be using, well, you can for Harvey, but for the other three, you should not be using public versions of those items and tools. Now that's it too. I would also be cautious and not put personal questions in your firm ones either. So just make sure which one you are using or logged into.
What about, Adam, for negotiations kind of with the other side? I mean, we've been talking a lot about kind of marking up a document. I would assume there's some level of like kind of back and forth negotiations. Maybe it's just all red line on top of red line, but to the extent there's AI use in kind of those perhaps initial negotiations, or is it really just used in trading red lines back
I
and forth?
think also I would say negotiations are becoming less common. Yeah, I don't have them on probably, I don't know,
Interesting.
80, 70% of deals. If anything, maybe we get on a call to talk through some stuff. But in that context, this goes back to the kind of my original point of treating AI just like an associate. I wouldn't go into negotiations expecting to the other side make a point and me turn to like a fifth year and be like, hey, how should I respond to this? Right. So everything you do, you should be prepared in advance. You should know, have your points. Usually often with negotiations, in transactional context, you know what points are going to be discussed, either because you've been trading red lines and it's been the same 20 points back and forth, or more common is even one side says, here's the issues list of the points we want to discuss, and here is our position.
Got it.
So you prepare in advance. So in advance, you could drop that into AI.
I was going to say, do you just drop the issues list?
Yeah. But then you're just treating it like anything else, right? Which in advance helping you draft. But I'm not aware of anyone like going to negotiations and using AI during it. I mean, a lot of negotiations are virtual, so I guess maybe someone I've been across from has used it and I didn't know, but I would think that would, slow things down. So it's just like any other thing we're using to be prepared and get ready, but then, you've got to go off your knowledge and head in the moment.
So kind of we're nearing the end of the hour. I want to ask like a couple kind of wrap up takeaway questions. I mean, we all hear these concerns, fears that AI is going to be the end of the junior associate. What do you see as kind of shaping the role of a junior associate over the next 3 to 5 years, and how they can best distinguish themselves within this atmosphere in which we all live now, that AI can do all this?
Yeah, I mean, I would say that like I've had this conversation with a lot of actually like in-house counsel where they've said like what is the plan, right? Like if we use AI for junior associate tasks, we can't only have mid-level seniors and partners because at some point you need to have another mid-level senior and like people progressing to partner. So like junior associates can't be fully replaced, right? But that just means they have to bring a different value. So that means that they have to kind of like master how to use the new technology, because I feel like AI tech changes every day. That's part of the reason why I feel like firm policies change every day. Um, and so mastering how to use that to then be efficient and deliver the most valuable output, right? So if a junior associate knows that they can input a certain amount of documents and then refine how much they have to review, and then turn around work product that much quicker, I think that's valuable. Like for example, like we have a case that's with like the London Commercial International Arbitration Association, and they like you have to disclose AI use under UK law, but what the thing is, there were really tight deadlines. Like we had to turn everything around within like 30 days, and there was like millions of documents. So what we did was we went ahead and had TAR go through all the documents, and then the junior associates were coding it, and they were helping make the model faster and faster and faster, so that way like mid-levels and seniors could then decide what was applicable. So I think the idea is like bringing value, and showing how you can add value to these new technologies.
I think exactly, yeah. So I, it's not changing what the skills are that make you a good associate and make you, have you add value, right? I know we've hit this in other summer series, but it's the soft skills that are actually all within your control. So responsiveness, attention to detail, your attitude, those things are still what make you a good associate, even with AI. And we're currently at the stage where, maybe AI is like a decent third year, shitty fifth year or something, but so you still need a lot of review and input. And that time, over time it will get better, but that doesn't mean we still won't need people to review it. And the law firm model is layers of review, right? Not saying there's never a document where one person turned it or prepared it and goes out, but the model is review. And that's why you catch, mistakes and nits and busts because on, let's say, a transactional deal, common, even a leanly staffed one, you might have three people, so like a second year, fifth year, and a partner. And that's why there's review. Each person should be reviewing it. So I'll be optimistic and say we should just get better work product because you're adding a fourth layer to that, right? You have the AI do it, that the second or third year review, then the fifth year, then the partner. So even as AI gets better, we're still going to have those layers of review. I mean, because you still have it in the law firm model without AI, right? Even as, let's say, a partner works like exclusively with one associate, they progress through the ranks. The partner's still reviewing their work. Hopefully, they takes less time to review it as they get more senior, but you're still reviewing it, and not just sending it to a client without reviewing and revising. So hopefully, we just end up getting better work product.
Well, I will open it up to questions. We have about 5 minutes left. I don't see any questions in the chat, but to the extent anyone kind of has a burning question about AI use, from either kind of a transaction or litigation perspective, I will open it up. Otherwise, we can give everyone 5 minutes back of their hour. Hearing none, Vicky's coming back on.
Thank you so much. That will conclude today's webinar. Laura, Adam, Reeny, I really appreciate you all volunteering your time and expertise today. These all sounded like great tips for summer.